weird that we're separated by this podium.
Well, I'm going to stand up and talk at the podium.
What's that?
You know, I have a...
But I won't be able to see their faces, so don't make faces about my comments.
I do think, no, you should stand, in my view, look, I always take the position that if there's a podium, the speaker should stand at it, because you don't realize that for some people when you're sitting down, some people might not have a good view of you.
Let's stand.
Do your opening remarks from here and then back and forth.
Although I wish I were back so that we could see.
I hate it when you can't do eye contact.
Did they give you a, is there a picture, is there water
No,
up
I
here?
just took it from the table.
Oh, okay. Go for it. I was disappointed. Henry Monahan said he was coming up to Boston, and I was going to give him a tour. Oh, thank you, thank you. He was going to come up to Boston for the unveiling of Sandy Lynch's portrait. I was going to give him a tour of our new building, but now I just got an email from him saying he's not coming up.
Really?
Welcome back.
That's too bad.
We are going to resume our programming now. Please do continue to eat your lunches. I don't think I can prevent it, frankly, but please feel free to continue to eat your lunches. I'm Dean Reuter, the Vice President and Director of Practice Groups at the Federalist Society. Welcome back. I saw most of you here this morning, but I welcome the new arrivals. And again, welcome the folks who are joining us on our webcast or watching a recording of this. I hope most of you were able to see our previous panel just concluded on the presumption of constitutionality. I personally was hoping for sharper disagreement and more discussion, but we'll settle for what we had there. Before we begin this panel, I want to make a brief commercial announcement for the Federalist Society's Teleforum conference calls. These are calls that are much like the programs that you're hearing today, but they just take place in the form of a telephone conversation that our members dial into. You have to be a Federalist Society member to participate, but they're very timely, very topical. In fact, we've just scheduled one at 4 o'clock today. If you don't get enough Federalist Society content today, you can rush back to your offices. At 4 o'clock, we're hosting Professor Eugene Volek, who's going to be discussing the 2 free speech cases decided just this morning by the court. So I'd welcome you on those calls. For now, though, however, our luncheon panel will be discussing the incentives behind congressional delegation. We're very pleased to have an expert panel. I want to give special thanks to Professor Naomi Rao, who was instrumental in assembling this panel, conceiving of it in the first instance, and then recruiting the speakers. We're going to get opening remarks from each of our panelists of about 12 minutes, then some discussion, and as always, see the microphones in the middle of the room. When we get to the Q&A portion, if you have a question, please feel free to join the conversation. We'll hear first from Professor Naomi Rao. She's a professor at George Mason University School of Law right here in the Washington, D.C. area. She'll be followed in opening remarks by Professor Jack Bierman, the Boston University School of Law, where he is the Harry Elwood Warren Scholar and Professor of Law. And then finally, we will hear from Professor Gillian E. Metzger. She is the Stanley H. Full Professor of Law at Columbia University School of Law. So with that, I will get out of the way and turn things over.
Great. Thanks so much, Dean. It's a pleasure to be here at the Executive Branch Review Conference. And so we're going to talk a little bit today on this panel about some of the incentives behind congressional delegation. So over the last 70 years, delegations of open-ended authority to executive branch agencies have really changed the relationship between Congress and the executive branch, feedback here, mostly in the direction of allowing the expansion of executive power and the diminishment of Congress. So then there's this question of why does Congress delegate so much authority to the executive branch? And the short answer is that members really get a lot of benefits from delegation. And I want to talk about some of those benefits, some which are quite obvious, some perhaps less obvious, and talk about how delegations really disrupt the separation of powers by allowing the executive branch and members of Congress to collude over administrative power. And this has weakened Congress as an institution and its ability to serve as an effective check on the president. Okay, so individual members of Congress have lots of incentives to delegate, and as must be probably familiar to many of you here, one of the primary reasons is that lawmaking is difficult, right? And delegation makes it much easier to pass laws. by leaving the details sort of blank, members of Congress can leave the tough choices to agencies, and they can take credit for doing something while leaving agencies to work out the details and perhaps take the blame for the implementation of those policies. Another benefit that members get, which I think is often much less visible, particularly to members of the public, is that delegations can actually give legislators a kind of individual power to influence and to control administration. And we can see that members of Congress do this through a variety of mechanisms, many of which Jack talks about in his article on congressional administration. And some of these mechanisms of control are formal, such as oversight hearings, but there's lots of influence and control that takes place through informal mechanisms, through contact between congressional staff and agency officials, right? This is going on all the time. You know, perhaps a few examples of this, oftentimes members can secure particular waivers or exemptions for their constituents or special interests. You know, a few years ago, after the passage of the Affordable Care Act, it was reported that the Health and Human Services Agency had granted some 20% of waivers under the ACA to businesses in Nancy Pelosi's district, right? So 20% of the waivers went to one congressional district. But you know, members can also shape administration in more, you know, sustained ways, right? John Dingell was very famous for this and his control over regulation. You know, today, you know, a more modern example might be Senator Elizabeth Warren. Many people have said to me who work on the Senate that there's sort of a shadow Consumer Financial Protection Bureau being run out of her Senate office, which perhaps is unsurprising since she was instrumental in designing and bringing that agency into existence. But so you can see that members have lots of ways to take actions where they can influence and control administration. And when they do this, their influence is often reflecting narrow interests, and it's very unlikely that these actions are going to be representative of Congress as a whole, or even of a majority of the members of Congress. And so members want to delegate not just to shift blame, but because they get individual benefits from delegation. And they may be better able to engage in the types of activities that help them get reelected, like serving constituents and special interests. And delegation has the added benefit of allowing them to do this in a way that is largely invisible to the public. So this, I think, this dynamic really raises some fundamental structural problems. Because this dynamic means that individual members of Congress, their interests will be less aligned with the institutional interests of Congress as a whole. So in our system of separation of powers, we have this Madisonian idea that government officials should pursue the ambitions of their respective branches. And this is, you know, easy to understand in the context of the executive branch. The president is a unitary actor, and his personal ambitions will easily align with pursuing executive power. The mechanism for assigning the interests of a multi-member body, such as Congress, with the institution of Congress, is much harder to figure out, right? How do you align the interests of 535 lawmakers with one institution? And the Constitution, I think, provides a very simple answer to that question. The answer is that it gives Congress only really one primary power, and that's a collective power to make laws. And so members of Congress have to act together to pass laws, and they're not given any individual power whatsoever. And so even though members, representatives, properly represent particular places and particular interests, if they want to serve those interests, they have to work together for the public good by passing laws, because that's the power that they have. And so this aligns the interests of congressmen with the interest of Congress as a whole. And what delegation does in a very kind of fundamental and structural way is that it unravels this connection, because it allows individual members, individual lawmakers, to exercise the particularities of the executive power or the administrative power. And so delegation not only yields too much power to agencies, which is of course a criticism that we frequently hear, and of course is valid, but it also allows lawmakers and members of Congress to exercise that discretion. And this violates another very fundamental precept of our system, which is that the lawmaker cannot be the law interpreter. right? This separation between law interpretation and law making is really essential to our constitutional structure. And we see it in the basic design, right, which is that Congress makes the laws, but the execution and interpretation and application of those laws is left to the other branches, right, to the executive and to the courts. But what delegation does is that it allows both agencies and members of Congress to combine these functions, to combine lawmaking and law interpretation. And you can see Justice Scalia raised some of these same concerns in this term in Perez versus Mortgage Bankers Association. And he wrote a separate opinion talking about this problem in the context of agencies. And he noted that, as we all know, agencies make regulations under very open-ended delegations, and then they get to administer and interpret their own regulations. And Justice Scalia said, this is a problem, and that courts shouldn't defer to an agency's interpretation of its own rules, because that allows the agency to combine lawmaking with law interpretation. I think this is a very valid point in the context of executive branch agencies. But really, in some ways, it's perhaps a more significant problem with Congress. Because the executive power has always included the power to fill in the details when interpreting and applying the laws. And the executive power, like the judicial power, includes a certain degree of discretion. We might disagree about what the scope of that discretion is or how that discretion should be exercised, but discretion is an inherent part of the executive power. Now, in sharp contrast, members of Congress are given no part of law interpretation whatsoever, right? The Constitution instead very carefully separates members of Congress from the executive power. And that idea runs throughout the text and structure of the Constitution, but is also extremely explicit in the incompatibility clause, right, which is the clause that says members of Congress cannot serve as executive branch officers. And that clause, along with other things in the text and structure of the Constitution, prohibit a parliamentary style of government. Moreover, Article 1 gives members of Congress no interpretive or executive powers whatsoever. And so when members of Congress are perhaps meddling in administration, they could do so in a way that both exceeds the legislative power and interferes with the executive power. And so rather than competing with executive agencies over administration, members may delegate so they can collude in the exercise of administration. And they can work with administrators to further their particular goals and to serve various interests. And this really undermines one of the most important checks on the expansion of government power. Delegation makes it easier to enact laws, and it allows both the agencies and the lawmakers to combine the lawmaking and law interpretation functions. But I also want to stress that this power of members over administration may really be a kind of short-term benefit of delegations. So although individual members of Congress have incentives to delegate, continued delegations, as we've seen over the last so many decades, have weakened Congress as an institution. And we see that members, because they have other ways of exercising power, they're often less focused on lawmaking, right? It's perhaps one of the many reasons that people are so despondent about Congress's inability to actually legislate. Lawmaking is hard. Working on administration may be easier, and you get individual benefits from doing that. And in this context, like in so many other contexts, the increased political polarization and party polarization contributes to the problem, right? Lawmakers often cases will identify more with their party than with Congress as an institution, and that can also, in many instances, make it harder to enact legislation. And so, one of the results of this is that when it's unlikely that Congress will use its lawmaking power, and in some instances, Congress can't even really issue a viable threat of legislative action, it becomes much harder for Congress to serve as a check on the executive. Because it's really the lawmaking power, right, the exercise of lawmaking power that justifies and stands behind congressional oversight. And if no one believes that Congress will legislate, its oversight will have less force. And we see one consequence of this, of course, is that the power of the executive branch continues to increase at a rapid pace. And so delegations may benefit individual members of Congress, but oftentimes that benefit or that influence is going to be intermittent or sporadic. It may often be on a small scale. But the executive as of course it properly should be, is going to be the primary beneficiary of delegations. And so I want to suggest that members of Congress actually have a self-interest in exercising a more robust legislative power. Tinkering with administration may be easier, but it's often less effective. And the collective power of Congress, the lawmaking power, is really where Congress draws its strength. And so I think to have a more robust system, to have a more Republican government, a more deliberative government, we really need to find ways of channeling Congress's collective power. And that will increase Congress's effectiveness, and it will also provide a better check on the executive. And so why does this all matter? For that, I would refer you to the separate opinions of Justice Thomas and Justice Alito in the Amtrak case this past term. Delegations undermine accountability. And as I pointed out, that works in a lot of ways that are often not visible. And perhaps most importantly, delegations undermine individual liberty by allowing for the unchecked expansion of the regulatory state. Thanks.
Thanks. That's going to be a tough act to follow. And I want to say that I'm really always very happy to be at Federalist Society meetings, not only because I think I was at the first or second meeting together with my classmates, Lee Otis and David McIntosh, who I'm not sure if David is still here, but also because after that I went to the Critical Legal Studies Conference for my dose of crazy legal views, and since those meetings have stopped, I have to come to this to fill that niche in my professional career. So I'm really happy to be at a Federalist Society meeting. It's my replacement for Critical Legal Studies. So I want to say I want to make basically two points, but in order to make them, I'm going to have to go over some constitutional basics, unfortunately. The two main points are, first of all, that the problem that we're talking about, excessive delegation and individual members of Congress meddling, is actually a product of our constitutional structure. It's not a defect in current understanding. It's actually consistent with and a product of what the framers set up. So if you want to change that, you really got to change the structure of the Constitution, which I know is not maybe a real possibility. And the second thing is that I totally agree with all the notions of how members of Congress have these incentives to act in this way, but I really don't think the problem is all that serious in the writ large in terms of the effect of this in policy. And I'll try to explain all that in 12 minutes. I mean, I totally agree, and I think that the political science literature has told us for a long time that individual members of Congress, former President Company accepted, act in Congress only to advance their own self-interest, whether it's to be reelected or to help their friends or to advance their ideological views. They're not there thinking, oh, how can I help the United States or help this body, Congress. The political scientists have told us for a long time that it's all about what can I get out of this somehow or other. And I think that's something that the framers understood, and they structured a constitution to try to ameliorate those problems, and they sort of failed in some ways. And it really shouldn't be considered heresy to criticize the Constitution and the framers. I mean, we would all agree that there were some defects in the Constitution, right, having to do with like slavery and the right to vote and that sort of thing. And so there were some other structural ones that just aren't as obvious. And the basic understanding, though, is that there's this fantasy that we have this system of separation of powers in the Constitution that provides the perfect blueprint for deliberative democracy and good regulation only when necessary. And that if only we hadn't eaten the apple and at the time of the New Deal, we would all be in this perfect Eden of government. That the plan was perfect, but the execution of it by us as mortals has failed. And I just don't think that's true. I think that the version of separation of powers in our Constitution suffers from a very serious problem of overly separating the legislative and executive branches in terms of personnel. And what that has meant is that we need to have informal ways for the members of the legislature to maintain the kind of influence that is common in parliamentary systems. And in fact, just to build on something that David McIntosh said in his presentation, which I think is important to this subject, it's true that members of Congress can pass legislation and then sort of abdicate responsibility when it comes to the execution, because there's this strict separation between Congress and the executive branch. In a parliamentary system, the minister can't do that, because the minister is part of the legislature, right? So the legislature is responsible for everything that happens in the executive branch. Now, in our system, it's actually also true, but we can hide behind this facade of separation of powers and allow members of Congress to avoid that sort of responsibility. So let me just go, I want to go through some separation of powers basics and get back to this theme. So basically, we don't have a separation of powers clause in our Constitution. We don't have that provision. What we have is a collection of very specific structural and procedural provisions that are relatively strictly enforced by the Supreme Court. And then we have this sort of vaguer principle of the idea of separation of powers, that no one branch can sort of excessively intrude on the working of another branch. Each branch shares substantive responsibility over every conceivable subject of federal regulatory power, unless there's something specifically in the Constitution that assigns it to one branch. And just quickly, to give a very recent example of that last sort of thing, the Zivotofsky case about whether you have to put Israel on the passport of someone who's born in Jerusalem. The Supreme Court, rightly or wrongly, decided that that power was, in the Constitution, was specifically given to the president, and therefore Congress couldn't mess with that. Now, whether you agree with that or disagree with that, that's the form of decision that that was. But in most cases, things like the Appointments Clause or the requirements for passing a law, the court will enforce those very, very strictly. But and as long as each branch follows those procedural and structural provisions that apply to it. So what are those? Well, we know for the legislative branch, it's bicameralism and presentment. What is it for the executive branch? It's appointment pursuant to the Appointments Clause, and it's a delegation of authority either through a statute or through the Constitution, right? And so in most cases, it's delegation of authority through a statute. And my own view about the delegation doctrine is really it should be understood as a principle of ultra vires. That is, that the problem with President Truman's seizure of the steel mills wasn't that that there was a delegation which was too much power to the president. It was that he didn't actually there was no statute that said that he could do that. So, for example, my understanding of the delegation doctrine would be if Congress passes a statute that says the executive branch should do something that's nice, right? I think my colleague Gary Lawson always talks about the Niceness and Goodness Commission, right? That would not give the executive branch the power to do anything. Maybe give out candy on Halloween, but that's about it. And so you would just hold anything they did as ultra vires under that statute, unless they had some other statute or some constitutional provision that gave them authority to what they did. Now, so the executive branch has those procedural and structural requirements, right? A proper appointment and a delegation. And the judicial branch has, obviously, that they have to be appointed and protected under Article 3, and they have to have a case or controversy before them. As long as the branches operate properly, they can do almost anything that might be viewed as within the purview primarily of another branch. An example would be clean air standards. Right? Congress can pass very specific clean air standards, or it could delegate authority under the law for the executive branch to come up with the specifics. And as long as Congress does bicameralism presentment, whatever it says is law, if Congress delegates adequately to the executive branch, then as long as those people are appointed properly and subject to some minimal level of supervision by the president, then they have the power to do it. And if there's a case or controversy that comes before the courts, and the court has to formulate some sort of standard in order to deal with the law, then if the judges are properly appointed, they can do it. So there's this shared substantive responsibility across the government. And so the non-delegation doctrine fits into that second category of constitutional separation of powers limits. It's not a textual one. It's a question of is the delegation too extreme to meet some sort of vague notion of separation of powers? And the problem for the courts is that they just don't see how to draw that line. And so the Justice Scalia in the American Trucking decision explained that there's just no manageable judicial standard really to monitor this. And I understand that there's this problem of individual members of Congress being able to take advantage of these vague delegations to assert their authority. But I don't think that's really anything that's new or different about the way our government works. And I just want to go back. I was thinking of who decided that who the postmaster of Massachusetts would be in 1789. Do you think it was George Washington, or was it Elbridge Gerry, the representative from Marblehead? Or maybe one of the senators from Massachusetts. So the president has forever been taking suggestions from the legislature and how to exercise their authority. In my view, the saving grace is that on the big questions of policy, this really isn't a serious problem. There's no question that when an agency is deciding who to enforce against, or who to not enforce against, or relatively minor allocations of resources, that obviously outsized influence can be exercised by members of Congress. But when it comes to the fundamental policy decisions that agencies make, individual members of Congress have really very little opportunity to have outsized influence on it, because it's a public, open policy kind of matter. The only exception, I would say, is in independent agencies. That is because independent agencies are so far removed from presidential supervision that there are some circumstances, and I have a co-author who was on an independent agency who will tell you that there were members of that agency that would clear all of their decisions with members of Congress before they would vote, because that was their sponsor in being on that agency. So I would say that in most situations you don't have that problem. In a parliamentary system, you wouldn't even be concerned about it, because there would be this explicit pipeline between the legislature and the agency. So all of this really, again, is a function of our particular constitutional design. Now, so I guess I just want to conclude by saying that when you lamenting delegation because it gives individual members of Congress a lot of influence, the question I would have is, compared to what? Do we really want unbridled executive power over these sorts of things? I would probably take, if we took a vote here, I'd probably say most people, at least right now, would say no, we don't want unbridled power by the president. So now the question is, are we really concerned with individual members of Congress having too much influence? And I don't think that the answer to that is really yes. I mean, the Affordable Care Act, let's take that as an example. It doesn't say that the government should do whatever's in the public interest, convenience, and necessity in setting up a system of health care, and then the agency could do whatever it wants, right? It's not like one of those old-fashioned kind of delegations. It has a lot of pages and a lot of provisions. And so it's only at the margin that this kind of lobbying by members of Congress is going to have much of an effect. So I think, what could we possibly do? So it seems to me that, at a margin, even if you wanted to tighten up on the non-delegation doctrine, you really couldn't have much effect. Almost every federal statute that's been passed in recent memory would still survive any realistic non-delegation challenge. So how about congressional review? Well, we know congressional review can't work because of the fact that the incumbent president is likely to veto any bill that comes before the president out of the Congressional Review Act. How about review at OIRA? And the OIRA review, I think, used to be a great tool for keeping agencies in line. It's now become a mechanism for regulatory delay and paralysis, which may be good for from some people's point of view, but right now it's not working. There's too much delay and not enough is actually happening. Judicial review, giving judges more stringent judicial review over agency exercises of power raises a whole set of questions about the accountability of federal judges. Is that preferable to the sort of more political give and take that occurs now? So I think that it's important to think about, if we want to change it, what we would change it to. Thank you.
Hi, thanks. And I'm delighted to be here. And I particularly enjoyed Naomi's putting together this panel and her presentation. I think her presentation presents a lot of interesting issues. But in addition, I think she really deserves kudos for putting together a panel on a very timely topic. Obviously, issues of congressional oversight and delegation are somewhat front and center today. And in particular, the constitutionality of delegations, which always strikes me as the constitutional equivalent of a clown punching bag, because no matter how many times you pound it into the ground, it pops back up. It has hit the news of late with the Supreme Court decisions and concurring opinions that she mentioned. I thought I'd begin with actually a few remarks in response to the critique of delegation that she lays out, and then turn at the end towards articulating maybe a different approach to thinking about the delegation question. So I think she makes a very insightful point in highlighting the institutional dynamics of delegation and the distinction between power of an individual member and power of Congress as a collective. And I agree with her that as a descriptive matter, delegation does have an effect in terms of increasing the power of congressional subparts relative to the whole. Especially, I would think, actually committees and committee chairs. Jack has actually noted in the piece that we mentioned congressional administration. Jack has discussed these dynamics in great detail. And I also think that the influence of individual members has grown in particular in conjunction to growing polarization and the way that is playing into dynamics such as oversight and the kinds of individual holds on appointments and other actions that have been going on. I do, however, have a few questions and critiques of the concern that she emphasizes in terms of this dynamic about empowering the individual over the collective Congress. Now, one just to flag for the outset is that I think much of this empowerment stems not necessarily just from delegation, or not from delegation alone, certainly, but is also a result of many of the rules and procedures of how Congress has set itself up, right? So supermajority requirements, filibuster, the fact that it allows holds, how the legislative agenda gets controlled, and in addition is a result of polarization and divided government. That you can't just look at delegation in isolation and identify this as a problematic trend to be fully accurate. I also question whether the collective Congress is actually as undermined as she suggests. So just to flag from the outset, first of all, Congress still does have important powers, which you know quite well, but in particular budget and appropriations, right? Those are powers that Congress continues to wield fairly effectively. I also think, though, and this may go more deeply, I think it's very hard to separate out the interests of the individual member of Congress from the interests of Congress as a collective. As a practical matter, these are really intertwined, right? So think of it, if you think about legislation that has an earmark, right? Legislation that has a very specific writer that reflects the interests of a particular member of Congress, right? So that's one way that what seems like a collective measure actually has a lot of individual member aspects to it. And similarly, there are ways in which individual members may actually be standing in for the collective Congress. If the views of the individual member on a policy question actually reflect the view of the majority of the chamber, for example, then that member's wielding influence may actually be en route to asserting more collective power. I think this is particularly true when you think about committee chairs and the kind of power that they may wield and their relationship to leadership in a chamber. Now, one way you could get past this is to talk about sort of formal mechanism, right? Legislation, collective action, deliberation, versus these more, as she put it, informal mechanisms of influence. The problem with that, I think, just as a matter of argumentation, is that what she's talking about are very strong functional dynamics as opposed to formalistic ones. So I think there's more of a tension in switching to that. So I think Congress has a little bit more power as a collective, and I think that drawing this distinction between individual and collective is a little bit harder than she portrays. My bigger critique, though, really is that from the collective Congress's perspective, I think that the cure that she proposes, or the idea of pulling back on delegation, is going to be worse than the disease. And that is because I think in the aim of protecting Congress's power, what she is suggesting would actually undermine one of the main mechanisms by which Congress achieves its policy aims, and that is delegation, right? So Congress, Naomi mentioned many of the reasons why Congress delegates, right? There are some very skeptical, public choicey, less positive views, which have some weight to them, right? It allows Congress to avoid some burdens and regulation, get political credit, punt on tough choices, serves, as she mentioned, some individual members' interests. But delegation is also the most effective and efficient means to deal with difficult regulatory questions, matters of scientific or technological uncertainty. It's a way for Congress to also allow regulation to occur despite changing circumstances. There's what you could call a positive spin. To put the point more directly, delegation, and delegation according to broad standards, is, I think, actually practically necessary if Congress is going to regulate. And I think that's really the nub of the issue here, right? I think the ongoing attacks on delegation and the constitutionality of delegation reflect a belief, as Naomi put at the end of her remarks, that the administrative state has gone too far. And it's an effort to pull it back, right? It's this idea that our constitutional structure was meant to be one of very limited government, or at least that such limited government is normatively more desirable, and therefore a great deal of suspicion about delegation's constitutional bona fides. I don't actually share that view. I think that the Constitution does impose notable checks on the enactment of legislation, but it also grants power. And I think it says it also was intended to make an executive branch that could be effective in implementing the measures Congress enacts. Going back to something that Jack said, I actually think that our separation of powers structure has a few very specific requirements, and then you're talking about a general underlying principle. And when you're talking in those terms, you also have to take into account the contradictory principles. So the concern about too much regulation has to be balanced with the fact that the Constitution does grant important powers to Congress. It's also very difficult, I think, to draw a distinction between legislative power and executive power. I think these are not very well defined, or judicial power. And I think that the terms in the Constitution are quite simply much more textually and structurally open-ended than critiques of delegation's constitutionality acknowledge. I'm also not persuaded, by the way, by some of the accounts about the original understanding of delegation that have come out in recent years. I actually think there was much more historical variety from an originalist perspective in delegated arrangements than is sometimes acknowledged. At both the federal and the state level, we've had some really interesting histories of administration and how it functioned in both colonial but then in early United States development over time. I think it's a much more nuanced account from a historian's perspective than some of the constitutional argumentation has taken into account. There's always, of course, the point of if you're going to take the originalist view, you can probably guess from this I'm not actually an originalist, that you have to take into account that we're dealing today with a very dramatically different system, and you'd have to think about what those originalist understandings should mean today. I also think, quite simply, we are in a different world. And we are in a world in which we have an administrative state, we have broad delegations. Our practice of governing has transformed. Our government has been transformed. It is a transformation that the Supreme Court has repeatedly sanctioned. And I think resisting delegation today has to take into account the anti-democratic and disruptive effects of pulling back our current system of governance. It is also, I think, extremely unlikely to happen. I think as a matter of political, administrative, and judicial reality, delegation is here to stay. That being the case, what should follow? And I don't think that means that delegations lack constitutional significance. And in an article that just came out in Yale, I argued that the structural significance of delegation is that it imposes an obligation of supervision. So delegation is going to happen. What follows from it is that there has to be supervision of delegated authority, and that obligation, which I call the constitutional duty to supervise, has several different bases. It runs throughout Article 2, but it also runs from the structural principle of delegation. And in that guise, I think it applies not just to the president, but I think it also applies to Congress. In thinking about how the duty to supervise extends to Congress, you could say that I end up taking a very different angle on this than Naomi does. So she sees congressional review and oversight as at odds with constitutional structure. I argue that congressional review and oversight are actually mandated by constitutional structure because of the reality of delegation. From another's perspective, I actually don't think we're necessarily so conflicting. I think we're both tracing out implications of delegation in our government today. I wanted to close with just a couple of implications of thinking about a duty to supervise and how it might play into questions of congressional oversight. One of the points I want to mention from which actually relates to something that Jack said in terms of compared to what. I don't think that the courts have much of a role to play here. I think that policing delegations does involve very difficult line drawing and a real lack of judicially manageable standards. I also think poses a real risk of courts intruding too much into the other branches. And certainly that holds true if you think about judicial enforcement of a duty to supervise. That really goes if you've got the courts enforcing a duty to supervise on Congress, you can see what some of the real separation of powers tensions would be from that. So I'm talking about a duty that actually is for Congress to impose and take seriously itself. And I think in many ways the policing of delegation really does involve the political branches policing themselves. I also think that if you think seriously about a duty to supervise, it does give you a basis for some criticisms of Congress's current approach to oversight. I think that practice is very ad hoc. I think it is focused on the particular. And I think it is, in recent years, overwhelmingly politically driven and partisan. And I think as a result, systemic issues that go to, for example, how government is managed, the current status of the senior executive service, are we really putting in place adequate managers with adequate training, things like that, get less attention absent a particular political crisis or hook that gets individual members of Congress interested. And another major issue, though, that I think has to go on the table, and that has to do with funding. I think that one of the main ways that Congress is influencing what government does is through funding. And I think if you take seriously a constitutional duty to supervise, that leads you to start thinking that Congress actually may have a constitutional obligation to fund the government. It can certainly pull back responsibilities it has delegated, and if it thinks that the government shouldn't be doing particular tasks, that is, of course, well within Congress's powers to pull them back. But having not done that and having delegated the power, I think that it actually is at odds with the idea of having a constitutional duty to supervise the exercise of the power that you've delegated, to then not adequately fund or shut down the government so that those tasks can't be undertaken. Thanks very much.
We will turn to the audience soon enough, but I'm going to give Professor Rao a couple minutes to respond.
Okay.
You invited these people here.
Oh, I know. Yeah, I guess because I'm living still in that fantasy separation of powers world, pushing down the clown punching bag. So, you know, I guess that's just where I am. And you know, it's obviously we disagree about whether the non-delegation doctrine or the ability of Congress, you know, the idea that Congress should not delegate legislative powers, we disagree about whether that's a fundamental aspect of the Constitution, and I'm persuaded that it is. But I just wanted to make a couple of comments in response to the thoughtful remarks that were made. I guess going to Jack's point, you know, he suggests, and I think, you know, I mean, there's some truth to this. You know, how much influence do members of Congress actually wield on big questions? You know, I assume in many cases they don't wield that much influence, although I think in some instances they probably do. But my point's not necessarily about the magnitude of the influence that they exercise. Rather, it's about the fact that because they can exercise that influence, they are often, you know, their focus and their attention is shifted away from lawmaking, right? And so it undermines the collective activity of Congress. It undermines their lawmaking power, and it lets them collude with executive branch agents. You know, another question that a number of people have raised, you know, I have a paper about this that's forthcoming, and so I've presented it in a number of places. People say, well, isn't it better if Congress conducts oversight over the executive branch, right? I mean, do we really want, you know, unbridled executive power? And I think that is fair enough. We want Congress to be an effective check on the executive. But I think one of the problems is that through delegation, Congress isn't serving as a competitive check or an effective check. They're often just, you know, working with the agencies. And so it's not clear to me that what they're doing is often a very effective way of checking the executive branch. So just a few thoughts.
So if you have questions, please go to one of the microphones. And maybe while we're waiting, let me ask Professor Metzger a question. I don't know if there's consensus on the panel, but Naomi, Professor Rao had mentioned that members delegate specifically to avoid accountability. How do we reconcile that with their, what are the incentives, if that's the case, what are the incentives to provide oversight, for Congress to engage in serious oversight, if in the first instance they're getting rid of the power to get rid of accountability?
Well, I actually think that the political incentives here are more complicated than that. I mean, for one main one, if you think about it in partisan terms, and I think we see this, you know, a lot of political scientists have done studies of, for example, congressional investigations and hearings under divided government, and the evidence suggests that you actually get an increase in hearings and you get an increase in oversight Why? Because there are obvious partisan benefits from doing that. So I think if you focus on, Jack mentioned the idea of individuals' members' interests are their interests for re-election and their own partisan interest, that in and of itself can actually give them some significant interest in engaging in oversight and in engaging in the kind of supervision that I think is needed.
Can I just add something to that? Yeah, I think that there's two different kinds of oversight that we have to and we have to keep in mind: casework and then sort of more policy oversight. And I think one of the best things that happens for a member of Congress is that someone in their district doesn't get their Social Security check on time, because then you call the member of Congress to get it, and then you get another family that's loyal to you for the rest of their lives. So that's sort of a documented phenomenon. But on big policy issues, of course, just like in the collective body, a member of Congress can get support even in a losing cause for in arguing against legislation that's going to pass, or arguing in favor of legislation that's not going to pass. The same thing happens with oversight. That is, if you're from a coal state, and even if you're fighting a losing battle against an aggressive Clean Air Act implementation, you use the oversight opportunity the hearings as an opportunity to state your position for your constituents, and that, to me, that's a good thing. That's a good thing about a democracy. The bad thing, of course, is if you're going in a back room without any public scrutiny and pushing the regulation in one direction or another. But again, I just don't think that that's a serious problem in big policy questions. And I also don't think there's any constitutional issue there, because obviously no individual member of Congress can do anything with legal effect. The only entity that can do something with legal effect in that case would be the agency.
Let's turn to the audience and start the microphone in front.
Thank you. My name is Tom Christina. I'm a practitioner from South Carolina. My question is for Professor Metzger. Is your theory about a duty to supervise grounded on some principle of the common law of agency?
It's actually, as I derived it, it's more based actually on constitutional structure. So agency insofar as you see those principles in the constitutional structure, but it's more, when I look at so I said there are two bases for it. One is Article 2, and there I think in Article 2 you see a number of provisions that sort of set up a bit of a hierarchical structure and superior, inferior supervision, norms, phrasing of the take care clause. These are, I think, somewhat familiar points. And then in terms of delegation, it's honestly a principle of accountability. And there you could say there's some kind of agency aspect, but political accountability is one of the reasons why I do think you need to have supervision. I think that without supervision, actually it's impossible for those who are elected to sort of set policy, to know what's going on at the ground level or to affect it. And supervision is a very important mechanism for that. And similarly for legal accountability, the idea that you're going to ensure that actions by the executive branch are taken in accordance with law, you also need supervision within the executive branch for that. So those are the main bases on which I derive the idea of a duty to supervise. The tricky questions are, I think, honestly, about the degree to which it can be enforced. Should it be enforced indirectly through administrative law? Probably is the main basis for it.
That was why I was asking. Yeah. Thank you.
Mm-hmm. Microphone in the back.
Hi, I'm John Barry, one of the inside the Beltway litigator types, and I'm sure is half the people in this room. So we talked about non-delegation a little bit. A couple interesting statutory constitutional proposals I've seen that could maybe sidestep some of the administrability problems with a robust non-delegation doctrine. One is the REINS Act that's been talked about. I recently came across something else which was intriguing. I wanted to get the panel's sense on what they think the consequences would be. It's currently called, I think, the Regulation Freedom Amendment, where any regulation, not just major rules, that are flagged by some minority of Congress would then be put through bicameralism. So that could be 1/5, 1/4 of the members of one house or both houses, whatever, could then force both houses to affirm the regulation before it takes effect. I'd be curious to know what the panel thinks about what the consequences of that kind of rule would be, and if they think it'd be desirable or not.
Well, any legal effect by less than bicameralism presentment by anything a member of Congress does is, I think, per se unconstitutional under the Chadha decision. So now I would say that, you know, an improvement on current oversight at the federal level could be based on what happens in a lot of states. They have this thing called the Joint Committee on Administrative Rules, where all rules have to be funneled to this joint committee of both houses of the state legislature. They have a professional staff, something like what OIRA has for doing review of regulation, proposed rules. And those rules, that agency, the rules can't take effect until that agency has time to review, that committee, I'm sorry, has time to review them. And in many of these state laws, those agencies, those committees, if they come out with a resolution, a proposed resolution to reject the rule, then it automatically delays the effective date of the rule. I'm not sure that's constitutional on the federal level. It may also be unconstitutional in some states, but I think that's a good model, and I would think as a normative matter, that's a step in the right direction in terms of accountability. I think one of the reasons why legislators may not like it is because it makes them accountable for everything. If they don't do anything about it, then obviously they're responsible for it. So, but I don't, you know, I think you could, I can't imagine the current Supreme Court saying that there's a de minimis exception to Chadha, which would say that some sort of a delay or like what you're talking about would be constitutional.
I tend to think, bottom line, I agree with that. I think there's a difference between everything requiring approval and some kind of trigger that would be some subpart of Congress that would trigger it. So I think that would be the distinction between the two.
Yeah, and also there would be a question of whether is there presentment to the president in that proposal? I mean, or is it just, so it would go to the president as well? I mean, I think I agree with what Jack and Jillian said then about that, but I also think it's very unlikely that a majority of Congress will want to be bound to have to review regulations that a minority of Congress wants them to vote up or down on. So I think it's probably impracticable.
Bill Bonner, Media, Pennsylvania. I have three concerns about what's been said. Number one is the obvious one that we have a parallel court system, and that prospectively, as the parallel system gains power, has a profound impact on the three branches of government, creates a fourth one. The second issue relates to originalism, which you've referenced, and that is if you want to bring up a constitutional issue before an administrative law judge, you're going to be spinning your wheels. So if the government decides that they want to go to an administrative law judge because that's where they're going to get the best results, then you just lost your constitutional position. You've got to figure out how to preserve your interest so that you can get in front of a Article III judge and pursue those interests at a later time if you don't give up for economic reasons and do a consent decree, which will be used against other similar litigants. The third issue regarding supervision has to do with the supervision of the Secretary. The authority to issue regulations is issued to the Secretary, and what we have in the system right now is increasing layers of supervisory authority between administrative law judges and the Secretary, which violates the system which was set up. And so we don't have administrative law judges that are under the supervision of the Secretary directly. They're under the supervision of other supervisors down the feeding chain. These are all serious problems, and I don't hear them discussed, referenced, or of any concern to anyone.
If I might, so just taking those in reverse order, I think it's interesting, your point about the delegation to the Secretary. In terms of layers of supervision, that would be obviously a statutory. You're talking about a different kind of relationship that was intended. That would be a statutorily based relationship if it was supposed to be more immediate. I think actually if you think about supervision, it does emphasize the idea of decisions ultimately being made at the significantly politically accountable level in an agency. So it actually fits with that part, but I think any difference there in terms of supervision of ALJs would really go to whether or not the independence that's protected by statute is being interfered with, for example, under particular schemes. In terms of raising constitutional issues, that's actually, I think that's a really interesting issue. I actually have argued elsewhere that there should be more emphasis on agencies taking constitutional issues into account. I disagree, for example, with the line in Fox Broadcasting that failure to take into account a significant, that we should separate out constitutional issues and arbitrary and capriciousness review. And part of the reason for that is, I think, because so much of the implementation of law is happening at the administrative level, I think that actually it's important that constitutional issues of significance be able to be raised there and taken seriously. And then in terms of the parallel court system, one of the interesting issues here, I think, is if you focus, by that I'm assuming you mean the administrative law system and administrative adjudication. And one of the interesting things about some recent decisions, like Stern or Wellness this year, is the degree to which I actually think they have gone out of the way not to call traditional administrative adjudication into question. I think we're still very solidly grounded in Crowell versus Benson on that. And that where we've seen Article 3 pullbacks has been really in bankruptcy or these other areas which, with particularly in Stern, the carve-outs. You say, we're not questioning administrative adjudication, we're not questioning administrative adjudication. So I actually think that in terms of constitutional support or judicial support for a pullback in terms of grants of adjudicatory authority, that's less likely to happen than even pullbacks of delegatory policymaking authority. To the extent we've seen that come up, it's been more in the rulemaking, interpretive, guidance level, not in specific grants of adjudicative administrative authority.
I think all the issues I brought up, plus Chevron, just discourage businessmen when they see an administrative proceeding. They just give up and they look for the cheapest way out, and that's a consent decree, and it creates bad law.
Right. Now, I want to raise one issue, which one of the things I said in my presentation, if you recall, was that one of the structural requirements for administrative action is that the administrator be under some sort of adequate supervision of the president, and that's very vague. That's in that second order kind of separation of powers norm, where it's not a specific procedural or structural provision, but it's the example is the PCAOB case, where the Supreme Court said you can't have double for-cause removal restrictions, and in a footnote they carved out administrative law judges. And some case is going to come up where someone's going to complain that they were penalized by an administrative law judge who was not subject to no-cause removal by their supervisor, who was also not subject to no-cause removal. And my guess is the Supreme Court will uphold the double for-cause restrictions for administrative law judges.
Yeah, and I think there's some cases working their way through the courts that are raising precisely those questions. So it'll be interesting to see what happens.
You want to go first, Gene? You were standing up first. I thought all your remarks were very interesting, very thought-provoking, but David Bernstein from George Mason Law School. But I also got the sense that we're maybe a little bit behind the times what we're arguing about, because to some extent we're debating the classic Federal Communications Act, necessity, convenience, whether Congress could delegate all this very broad authority to the executive branch. But it seems to me that in recent years the bigger problem is the executive branch exercising authority that clearly was not delegated to it. I'll give really three real quick examples. TARP, which was supposed to make money available to financial institutions, that's a word of the statutes, wound up with an unelected car czar who was literally running day-to-day decisions of General Motors without any statutory authority that I could think of. The Libya war, we know that Congress didn't vote for it, but most of us don't know that Congress never allocated a penny for it, and that the president just manipulated funds from other things to pay for it, so we wouldn't have to ask Congress for it. And third, the infamous recent Title IX, people call them the new Title IX regulations, that require every university to change the system for dealing with sexual assault. There are actually no regulations out there. There's a Dear Colleague letter from an Undersecretary of Education with citing no authority, no Supreme Court case. It just says, I think Title IX requires you to do this without any legal analysis, without any notice and comment, without anything else. So it strikes me that we do have this real problem where the executive branch is exercising not broad delegated authority, but authority that isn't in the statute at all. And what do we do about that?
Okay. Yeah. So I guess I think, David, that the problems are somewhat related, in part because so much open-ended authority has been delegated to the executive in so many overlapping statutes in so many areas. It gives the executive branch kind of the feeling that it can, that they can act because somewhere there's some statute that supports what they're doing. And so I think that I think you're right that it's a separate problem, but it's related. It's related to a kind of mindset about what the executive power includes.
Do you want to finish?
In my presentation, I said that obviously one of the requirements for executive action is that they have a power either delegated through a statute or something explicitly in the Constitution. So insofar as the examples, whether you're correct legally, I know that Title IX, in my view, it's a pretty outrageous assertion of power without much legal support. That actually arose from some consent. It had a little bit of consent decree flavor to it also. If a case comes up to the Supreme Court, let's say, for example, let me just draw an issue out of the hat about the deferred action on immigration, which is going through the courts right now. I mean, the courts are perfectly there, ready to say there's no statute supporting this, and therefore you can't do it. So I don't see that as a constitutional problem. It's a political problem, and the president might be acting illegally or the agency, but the courts are there to stop it. As ultra vires, they just haven't been delegated the power.
In some of these cases, it's very hard to figure out who would have standing.
I think that's,
Right.
well, I also think it's a big problem. It's sometimes hard to figure out whether it is ultra vires, right?
Well,
courts can do that, but
if it's not, then they've been given power and they haven't done anything wrong.
Right. I mean, I would agree that when you're talking about statutory authority, obviously that's the check for it. But your point about standing, for me, underscores the fact that looking to the courts to be the enforcers, so your Libya example, for example, right? Essentially, Congress is also going to have to enforce its powers there. And part of the problem is that Congress doesn't want to be voting on questions of war. And I don't think it can just be seen in that case as a case of executive aggrandizement. It's very much also a case of congressional failure.
And, the remedy for that is impeachment, obviously. If a president is making a war that's not authorized, and a fellow named Robert Bork testified in Congress a long time ago that when Congress was trying to prevent President Nixon from ordering the bombing of Cambodia, that Congress had no power to do that, that was an executive function based on his status as commander-in-chief, and Congress couldn't mess with that. So I think there's a lot of interesting substantive constitutional questions that, lurking in the background of that. But their remedy is impeachment for an undeclared war. I mean, not for statutory issues, but for that.
Gene Meyer, Federal Society. I was sort of a somewhat minor point maybe, but I thought there's an intriguing thing in Professor Metzger's presentation when she mentioned that Congress, the link between individual congressmen and Congress as a whole, and said they were fairly similar. And I think that's an important question. One of the things which empirically struck me as dubious about that is you look at the popularity of your average individual congressman and the popularity of Congress as a whole. There is clearly a chasm of difference in responses, and it makes me wonder about the link you proposed.
I mean, so you're right. That certainly is a very interesting disconnect between those two. I mean, I think it reflects that many of the dimensions, many of the reasons why you have individual congresspeople being popular in their districts, because how those districts are drawn, the lack of competitive elections, the incumbency rates, et cetera, are also factors that contribute to congressional dysfunction and inability to reach agreement and to take actions that therefore leave Congress as a whole to be fairly unpopular. So there's an odd connection there, even though they seem dissimilar. But I think it also goes to the difficulties in understanding, and it'd be great to hear from Naomi on this, sort of what the collective Congress is as an institution versus a majority of the chamber, of each chamber. So because the idea about the importance of legislation and collective action, sort of talking about Congress as an institution. And I think it's hard to understand that separate from what a majority of each House thinks is in their interests or their policy interests. And even from a constitutional perspective, I think that's really the role of Congress, is to be, as each House is majority, bicameralism and presentment. The bicameralism part is, as a majority, they're supposed to be enacting their policy choices. And if you focus on the collective aspect as that, then I think it is the case that with the current leadership structure, with the ways that the leadership of the party has greater control over committee assignments, over what gets to the floor, that when you have particular individual members of Congress wielding a lot of influence, I will leave aside, by the way, the filibuster from this entire discussion, because obviously that's different. Then you actually see more connection to the majority, and if you see the majority as the collective, you can see a linkage. So I think to break it apart, you really have to be thinking of some kind of institutional interest of the collective Congress that's separate from the interest in enacting a particular policy proposal of a majority of each House. That was my point, that that's the overlap.
I think it's a difficult question, right? Are there some institutional interests of Congress that are separate, as you say, from some gathering up of a majority of members of Congress? And I think it's a difficult question that needs to be worked out. But in part, I think one of the things you're saying is correct, right? That the interest of Congress is kind of the interest of what a majority wants. But I think what a majority wants can't be to self-delegate powers back to individual members of Congress, right? Because that's not permitted, because each member only has a collective power. So whatever that collective institutional interest is, maybe it's something like ensuring that we have Republican deliberative government, right? And that they're enacting laws together. Maybe that's a kind of idealistic view of lawmaking. But I think that that's part of it. But it's a difficult question to work out.
So besides for just asking members of Congress to sort of do their job better and write more detailed statutes, I guess people have mentioned both the REINS Act and some sort of constitutional amendment along those lines as a means of getting Congress more engaged in affirmatively approving rules written by executive branch agencies. My question is that actually going to lead to a situation where we see less burdensome, less intrusive regulation? Because it seems to me, from sort of the incentives that you all have identified that lead Congress to delegate so much authority, a lot of those same incentives would align to encourage Congress to just rubber stamp any rules written by the executive branch. I'm reminded of the Waters of the United States rule that came down in the past couple weeks, in that the White House had some sort of comment that the only people who are against this rule are people who want dirty water. And I just wonder if, doesn't that put members of Congress in a situation where they're going to say, oh, I'm against dirty water, I'm going to vote in favor of the WOTUS rule, just in the same way that they voted in favor of the Clean Water Act that created the delegation in the first place. And so if you agree, if there's any solutions as well.
I mean, the only thing I would say is that you're talking about a political problem, not really a legal sort of constitutional problem. The REINS Act has a lot of different provisions, mostly just designed to slow down the rulemaking process, and so that's about favoring less regulation. And I understand that that's really the goal of that. It really doesn't do much in terms of increasing accountability, because it would just prevent a lot of regulations from even happening in the first place. And if that's your goal, then those kinds of things are good. I think that your instinct is correct, that Congress is going to run away from actually having responsibility for every rule that's passed, and that's why I don't think they would ever pass a law that said that no rules can go into effect without their positive vote, because I think they certainly don't want to have every rule with a positive vote on it, and so they'd rather delegate it, let the agencies take the blame for what happens. And I think, but again, to me, that's a product of our particular constitutional structure, that if you had a parliamentary system, I'm not touting a parliamentary system as a cure for all our problems, by the way. It's not that I'm saying we should have change our constitution or whatever and become England or France or something, but I just think that if you had a parliamentary system where there wasn't this radical separation between the legislature and the executive branch, you wouldn't have that same problem, because the legislature would be intimately involved in all of the regulatory matters.
but it might further blur accountability, right?
Right.
'Cause they'd both be responsible.
Right,
and
much
who-
more
right.
accountability.
Or,
The majority
but
party
blurred
would be-
accountability.
The majority party would have to take responsibility for everything the government does.
Yes, Stephen Yelverton, I'm a Federalist Society veteran. This question's in regard to the Senate's treaty powers. Is the Corker Amendment an unconstitutional delegation of treaty powers from the Senate to the President?
I'm sorry, that.
And this is in regard to the Iranian nuclear deal and the Corker Amendment that was adopted by the Senate that muddled up the ratification process on any such treaty.
I have to say, I'm not, I would defer to you guys. I haven't actually looked at the amendment that much to know.
So this is a provision that it passed both houses of Congress and it's signed by the president, so it's law. It's not only the Senate, right?
It's by the Senate now.
Well, it can't be only by the Senate, or it wouldn't have any legal effect.
Well, it's quite muddled
Right.
as to what it says, but it appears to drop the number of votes down to 55, and making it easier to get Senate approval, Congressional approval, and you know, what the Corker Amendment says has never been made clear.
Right, so, well...
in media reports. So does this smell like a unconstitutional delegation of the Senate's power over treaties?
Well, you know, this raises, I don't really know the specifics of this particular law that well to comment on the specifics of it, but it raises a general issue about what is a treaty. And, you know, we have the fast-track trade legislation, which requires that certain trade agreements get presented to both the House and the Senate for votes. We have laws that require that on trade delegations, members of Congress be appointed to trade delegations. And you can say, well, that seems unconstitutional because it's a member of Congress doing something other than legislating. But of course, because those members of Congress can't do anything with legal effect, they're not violating any constitutional requirement. Nothing they do has legal effect, so it's not a question of something that would be bicameralism and presentment. But so there's these executive agreements. There's executive agreements that have to be approved by the Congress. There's executive agreements that don't have to be approved by the Congress. There's treaties. So you're asking, I mean, I think the sort of simplistic separation of powers originalist view might be that any international agreement has to be a treaty and therefore has to go to the Senate for the full advice and consent of 2/3 of the Senate. That hasn't been for a long time the way that it's worked in the United States. There are many international agreements that go through both houses of Congress with only majority votes, or that are made by the executive only. And there's a long tradition of that, you know, concurrent with the treaty power, that the executive branch makes agreements that aren't presented to anyone because they're considered only executive agreements in international law. So in order for something like what you're talking about to be declared unconstitutional, there would have to be a ruling that it's a treaty. And the courts have not done a very good job of explaining what's a treaty and what's not a treaty. So it's very similar to sort of what's executive power versus what's legislative power in the non-delegation area.
Okay, thank you.
Well, we are going to continue without a break immediately across the hall here with our panel on congressional oversight. But before we leave, please join me in thanking the panel.
Very good. That was really good, huh?
Oh, thank you. Oh, okay, thanks. See you later.
Yeah, I think it's an executive agreement. But there's a long, I mean, it goes way back to the Civil War era.
Yeah.